Hola, mi gente. Welcome to episode 10 of Books and Bachata, the podcast. I'm your hostess, Miss Malcolm Hughes, and the goal of this podcast is to discuss love and life lessons I've learned the hard way, but mostly from books and bachata. However, today we're going to do something a little different. I was recently reading an article in the New Yorker that you all see here on the screen that completely pissed me off. The article covers felony murder in the US, and it angered me to such an extent that I've decided to do a multi part breakdown of what I read. Today, I want us to read and discuss part of the article and the larger implications. My goal for this series is that I will do my part to bring light to what I believe is an injustice of the justice system. And hopefully, that will help all of us be more aware of the excessively punitive laws that exist and do something about changing them. So let's go ahead and get into it. First, before we delve into the article, I want to start with defining what felony murder is. According to the Cornell Law School, which I think is a great website if you're looking for layman's terms or very understandable descriptions of the law, it's the felony murder rule. The felony murder rule is a law in most states and under federal law that allows anyone who is accused of committing a violent felony to be charged with murder if the commission of that felony results in the death of someone. The people involved in the felony may be charged for murder under the rule even if they had no intention of killing someone. For example, if A and B attempt to rob a store and A accidentally killed an employee when breaking through a window, then both A and B could be charged with murder through the felony murder rule, even though B did not kill a person and A did not intend the outcome. Violent felonies typically includes burglary, robbery, arson, rape, and kidnapping. However, jurisdictions may expand the rule to other types of crimes, and some states, such as Georgia and Missouri, may apply the rule to all felonies. Also, the merger doctrine prevents the rule from applying when the felony may constitute the elements of murder. This means that if someone commits acts like assault that could have been murder, the felony murder rule cannot apply because the crime merges into the charge. For example, a 2009 California state case, People versus Saran Chun, disallowed the felony murder doctrine because the underlying felony, a drive-by shooting, was assaultive in nature. There may be an exception to the felony murder rule depending on the jurisdiction. Some states do not apply the felony murder rule to co-felons if they do not intend or know that someone was likely to be killed. Some states also have an exemption to the felony murder rule if the person who dies is someone else involved in the felony. For example, if A and B rob a store and the store owner killed A, this exception would prevent the application of the felony murder rule to B because A was a co-felon. States differ on what class of murder a felony murder falls under and what punishments follow. In some states, a person can even face the death penalty for felony murder. However, the Supreme Court has interpreted the Eighth Amendment in the case Edmond versus Florida to prevent the death penalty for felony murder for co-conspirators who did not intend for anyone to be killed during the commissions of the felony. The death penalty can still apply, according to the Supreme Court in Tyson versus Arizona, where the co-conspirators' actions showed a reckless indifference to human life and played a major part in the felony. And so the thing about felony murder that bothers me so much, and we'll talk about it more as we go through this article, is that on the surface, it sounds like it could be okay, right? That if you're committing a crime and if the crime that you're committing along with someone escalates, and maybe you're not directly involved in a murder, but it leads to death, then everyone who took part in the crime should be held accountable to the extent that it was a murder that happened, and you're all to be held accountable for that. However, as we all know, when you're sitting somewhere and creating laws or policies, once you actually get to real world application, is much more complicated and messy than that, right? So that's what we'll see here, right? How does this abstract law actually change or transform when you have real world application? And who does that most greatly impact most often? And to what extent should this law be widely applied? That's something that we're going to talk about throughout this series. But to start today, I want us to begin by going through the article and discussing it. But one thing I want to point out is what we see here. There is a difference between what you all are seeing on my screen and what's available on the New Yorker's website and the one that I originally read, which was the printed version, which came out in December. And so I want to take a look at it. I want you to show I want you to see what I originally read in comparison to what you see online. And I want to talk briefly about why there may be a difference, and then we'll get into the article itself. So again, what you all see is the original magazine that I received. And this issue is the December 18th issue, though it published earlier on the website. But what I want to highlight here is the title and the tagline. So as you can see, originally it was titled, "What Makes a Murder? How a Draconian Legal Doctrine Imprisons People for Killings They Didn't Commit." Now for me, that's very vague, right? It's very inquisitive in nature, not accusatory at all, just very investigative, as in we are gathering the information and we're presenting it to you. Now, that's in comparison to what we see here online, where the title was changed to "Sentenced to Life for an Accident Miles Away." And the tagline reads, "A draconian legal doctrine called felony murder has put thousands of Americans, disproportionately young and black, in prison." And I wanted to highlight that because it stood out to me. One, just thinking of the reader demographic of the New Yorker, it's usually middle to upper class, certain educational background and pedigree. That's who would have the physical copy. But then I think about the online version and I think about virality. I think about writing it in such a way that it is more inciting and really grasp people's attention more. So this is very accusatory in nature, and it's also very targeted. I feel like it's when you think of punchlines and trying to make sure that you're quickly grasping people's attention. And it also shifts the narrative, though, and that's also what I wanted to point out. And I'm not saying whether this is a negative or positive, but it does shift it in order to highlight that there is a demographic that's being faced with an injustice. And so I just wanted to highlight that for us to ponder on why we think that this may be and what the New Yorker was hoping to achieve with this. And obviously, there's a difference between what you will put in a magazine and what you will put online, again, to grasp readers' attention. But I want us to think beyond that initial aspect and think deeper into like what is the goal here. But I want to leave that for interpretation. What I want to get into now is the article itself. And so we begin. This is going to be a multi-part series because if you could see here, if we were to play it, yeah, so if we were to play this, it would be over an hour of audio. So this will be more than one podcast episode for sure. But what we see here is we have the picture, same picture from the physical article with the header that Sadiq Baxter is serving a life sentence without parole for a killing he didn't commit. And it's an illustration of a young man sitting inside of a jail cell with sitting at the window looking out with the red and blue of the police siren lights going off in the background. The article. In 1982, when Ian Marcus was 9 years old, his father left work and headed home to his family on Long Island on a new moped, only to be killed by a driver who'd run a red light. Here I was, this 25-year-old widow with a baby, Ian's mother, Donna, told me. After a year and a half after the accident, when a bearded guy who ran a Brooklyn meat locker asked her out, it took 10 friends to convince me to go. Her date, Dean Amelkin, arrived with a plastic train set for Ian. Before long, her son had a second dad, a second last name, and two younger sisters. The family relocated to South Florida, where Dean helped his own father run a graphics shop. Eager for Ian and his sisters to achieve more economic stability than he'd known, Dean pushed them academically, weeping with pride when Ian won a national debating championship in high school. Eventually, Ian went on to law school, landing a job at an elite Manhattan law firm. As a kid, he had watched My Cousin Vinny with his dad, and they'd agreed that lawyering looked fun. And so here we have this initial picture painting, right? A little bit of sadness, but we see the tide turning, and it creates a very beautiful family story of success and academic achievement for the children while continuing to persevere and pursue childhood dreams. Continuing with the article. One Sunday morning in August 2012, Ian, now 30, was in bed in Brooklyn when his mother called, distraught. Every Sunday for more than a decade, Dean had met some buddies at a shopping center, biked 30 miles to a beach and back, and then lingered over breakfast. But on that morning, Dean hadn't made it home. For the second time in his life, Ian had lost his father to a reckless driver. This shock was swiftly followed by another. As a result of the crash, which all parties agreed was unintentional, two men stood accused of murdering his father and a friend who was cycling with him. One of those charged, 25-year-old Sadiq Baxter, had never laid eyes on the victims. At the time of impact, he had been miles away, in handcuffs. And so, again, this now begins to lay that foundation of this horrific accident has occurred. It's impacted this family deeply because they're reliving old traumas because for the second time, they've now had the patriarchal figure in the household. Their life has been taken by an auto accident. And so, on one hand, we get that picture, right? I want to juxtapose these ideas in your head. On one hand, we have this family who is now distraught over losing the patriarch in their family. On the other side, we have two men being accused of murder, one of them never having even seen these individuals and actually having already been in police custody at the time of the accident. So we have two lives, more than two lives, but we have two families that are about to drastically shift and change at this same pivotal moment. Continuing with the article. When Donna heard the charges, she asked, "How is this even possible?" Ian had learned the answer in law school, a sweeping and uniquely American legal doctrine, often couched in terms of justice for victims' families, called felony murder. To engage in certain unlawful activities, the theory goes, is to assume full responsibility if a death occurs, regardless of intent. This is where I started to lift my eyes when I was originally reading it, because I don't think theoretically that that's even fair, right? On one hand, you can rationalize that if you're taking part in crime, you have to think it all the way through to the worst case scenario and what could occur and take accountability therein. However, that's assuming a lot. That's assuming that someone has the intellectual capacity to do so. We also know that when people are in distress, making life altering decisions, split second decisions based on survival, then folks are not thinking clearly and you're not thinking through to the worst case scenario. And I'm not justifying crime in any way. We're just talking about the facts. And because we know that people don't make the wisest decisions in survival mode, I want to pause here to actually highlight another article from Recovery in the Bin, a critical theorist and activist collective. And this one is titled Living in Survival Mode and Decision Making. When you're living in survival mode, making decisions can become particularly difficult, and you can find yourself struggling with indecision, avoiding decisions, or handing them over to others, or making suboptimal decisions. Suboptimal decisions can range from those that are okay, but you could have chosen better, especially for the longer term, to those that are outright bad or dangerous for you. The aim here is not to criticize the decisions made, but to try and understand why they were made, i.e., why do we make and keep making decisions that are not in our best interest? We'll think about the more general case of decision making in survival mode and emphasize some of the particular impacts of trauma, mental illness, and disability. A few points about decision making first. Decision making is cognitively effortful and takes time. It requires cognitive and emotional reserve. It requires consideration of the timescale of the execution and consequences of the decision. It requires taking into account your interests and goals, the various options to decide between, and their relative merits, downsides, and costs, often over difficult timescales. One of the major costs to be taken into account is the cost to yourself. It depends on the capital, financial, self esteem, social network you have available at the point of the decision. It depends on the options you really have available to you as opposed to the options that could theoretically be available. And so these are the things that I want us to ponder on and consider as we continue to read this and unpack Sadiq's case, where he was in life, and the choices that he made. Continuing the article. The precipitating offenses in this case: Sadiq Baxter had searched 5 cars for stray cash before surrendering when cops appeared, and O'Brien Oakley, his 26-year-old friend, had fled the scene, lost control of his car in a police chase, and killed the bicyclist. The prosecution charged both men with 2 counts of felony murder in the first degree. Recently, Ian spoke with me about the case while caring for his newborn daughter in Brooklyn. As we talked, he sometimes ran his hand down a thick beard he'd grown in homage to his dad. It's truly one of the cruelest ideas in the American legal system, he said of felony murder, and most people don't even know it exists. I agree, and this is why I wanted to come here and discuss it. It seemed unnecessarily cruel, and I had no idea that it exists. So I figured other people may not have any idea that it exists, and therefore it's allowed to continue to happen. But that's not the case. We'll discuss more of organizations that are fighting against felony murder, but that'll be in later episodes. Continuing the article. When Sadiq Baxter was 9 years old, he felt he'd discovered God after tasting the fruits of his parents' birthplace, Jamaica. He devoured the soursop, the star fruit, and the jackfruit. His father, a former cop in Kingston, took note. Sadiq's mother, who'd been raising him just outside Miami, soon asked her ex to keep their son on the island for a spell and instill in him some discipline and focus. One way to do that, the father decided, would be to teach him to nurture plants and fruits of his own, a project to which Sadiq became devoted. A month before Sadiq was arrested for killing the men he'd never seen, his father phoned him to relay a disturbing dream. Something very bad is going to happen, he warned. But this catastrophe might be prevented if Sadiq returned to his love of horticulture. At the time, Sadiq felt that something very bad had already happened, a string of bad things, in fact. In a 2009 Miami nightclub shooting, he'd taken a stray bullet in his tailbone, and the long recovery had cost him his job at the reception desk of a hotel. Can you believe I'm changing your pampers again? His mom teased as she took care of him. Just as his gunshot injury began to heal, she had a stroke, then died at the age of 59. In his grief and physical distress, Sadiq became addicted to painkillers. I think all of this context matters because when people make decisions, they're not in isolation. People don't make decisions in a vacuum. People make decisions based on the options that they believe they have as a result of the current status and situation they find themselves in life. That doesn't justify anything. There are always choices to be made, but context and background matters. Continuing the article. His father on the phone put forward another way to live. Couldn't he import Jamaican plants and sell them in Florida grocery stores for a hefty markup? Think Scotch bonnet peppers. And doesn't everyone love a poinsettia at Christmas? His son could do something he liked and make a living. Good idea, Sadiq replied, before returning to doing precious little. One Saturday night soon afterward, he and O'Brien Oakley played blackjack and downed free drinks at a suburban Miami casino. Long after midnight, having lost a lot of money and popped a Percocet, Sadiq left the casino with O'Brien and ended up in Copper City, a nearby community of backyard pools and luxe landscaping. It occurred to Sadiq, cruising the winding streets, that he could steal from cars to offset his losses. O'Brien, a singer-songwriter, told me that he resisted the proposal at first, but just before dawn, he found himself sitting in his parked silver sedan on a corner as Sadiq got out and looked around. Two things I want to point out here. One, I love his father's recommendation. However, that takes time. And quite often, when people commit crimes, they're doing so because they need money now, and the alternative would require time, resources, and access that they may not always have readily available. Again, not a justification, but an analysis of why people sometimes make split second decisions that are detrimental to themselves and others. The second point is what is happening between Sadiq and his friend. Now, this is a case of intuition with O'Brien. They had taken drugs and were under the influence of alcohol. So, again, not making great decisions, but O'Brien said he initially resisted. I am one who believes that we all have intuition. Some of us listen to it to a greater extent than others, but that was the moment to choose something different. Obviously, in hindsight, that's relevant, but it's important in our own lives to heed those warnings. Continuing the article. Sadiq was hardly inconspicuous. At 6 feet 9, he was so lanky that his mom had called him Coconut Tree. Still, he had the benefit of the dark. Like a kid up too early on Christmas morning, he discovered a drum set in one unlocked car and an embroidered bag of baseball equipment in another. Then he turned his attention to a black SUV sitting outside a home edged with palm trees. Inside the car, he grabbed a handful of change and a pair of sunglasses, only to look up and see a man striding toward him across the grass. Bradley Cantor, a healthcare entrepreneur, and his wife had just returned from taking their son to the airport when they spotted a stranger in their driveway. So he tried to saunter calmly away. Cantor ran back to his car and began driving slowly behind him, his wife filming on her phone as he called 911. The first of several Broward County Sheriff's Office vehicles pulled up in 2 minutes. Get on the ground, a deputy ordered. Sadiq was handcuffed on the grass while having a panic attack, not least because he was supposed to pick up his 4-year-old daughter, Denasia, that morning. So think back to that point in time when we discussed the juxtaposition of two families' lives who are dramatically being altered. Two families are both losing the patriarch. I just want you to reflect on that for a moment. Continuing the article. Moments later, O'Brien drove past. He had fled the scene when Cantor arrived, but had gotten lost exiting the neighborhood and accidentally circled back around. That's the car, Cantor cried out. O'Brien hit the accelerator, and multiple officers gave chase. They trailed him at high speed through a residential neighborhood. 18 minutes later, O'Brien ran a light and was struck by another vehicle. His car crashed into Dean Amelkin and his friend Christopher McConnell. Now, this is the moment where things change. Sadiq is in handcuffs. O'Brien is the one who chose to flee the scene and run a red light, going directly into an intersection and hitting two cyclists. So, this is where we start to formulate the question: are both of these individuals at fault for what has just occurred? I would say no, but that's what we're here to discuss. Sadiq learned of the accident shortly before he arrived at the sheriff's office, where he confessed to stealing from 5 unlocked cars. Wearing a blue hospital gown, his voice thick from medications he'd been administered after his panic attack, he asked the detective what would happen next. He'd be charged with burglary, the detective replied. 3 weeks later, Sadiq received a written copy of his indictment at a Broward County jail. According to a grand jury, both he and O'Brien did unlawfully and feloniously kill and murder 2 people. The prosecution had decided not to pursue the death penalty, but the first-degree murder charges were punishable by life in prison without parole. Later, Sadiq told me, that's when I went crazy. Understandably so. Now, again, his actions of burglary were not justified. But could you fathom having the thought that you will have to deal with 5 accounts of burglary, maybe vandalizing, and to have that then become you're being charged with first degree murder, 2 counts? Continuing the article. What makes a murderer? Intent is often assumed to be a factor, but for hundreds of years, the felony murder doctrine has muddled this conceit. I also want to talk about how, in what's depicted of our judicial system, we always talk about intent mattering. But it appears that maybe in the case of felony murder, intent isn't the most important component. And if that is the case, why don't we talk about this more often? Continuing the article. In 1716, the legal theorist William Hawkins argued that a crime like robbery necessarily tends to raise tumults and quarrels and cannot be attended with the danger of personal hurt. Any resulting death, he posited, was tantamount to murder. Such notions began being applied in British courts later in the 18th century, and almost from the beginning, Britons were questioning whether the felony murder doctrine was just. The question came to a head in 1953 when, despite widespread pleas for clemency, a 19-year-old Londoner named Derek Bentley was executed because his 16-year-old accomplice in a burglary killed a policeman during the crime. 4 years later, the UK abolished the doctrine, and other Commonwealth nations followed suit. The United States, meanwhile, went in the opposite direction. And so this is how we landed here. Where in the US, we have on our books this felony murder charge. But what does that mean for us as a nation? And as a nation of states, where each state can decide for itself how it wants to implement this felony murder charge, what does that mean for citizens across the nation? And how is this impacting families? This is also something that the article discussed and that we will further explore. Continuing the article. I also want to say that here online is something that we don't have in the printed version, and that is additional pictures of Sadiq. So what we see here is Sadiq with his daughter Denasia when she was 4 years old, and it's adorable. Honestly, it humanizes him in a way that I don't think you get from the printed version, and it reminds you that behind these policies and these laws, there are real human beings and real families that are being impacted and destroyed. And I understand the argument of that we all make choices, yes, but none of us are the worst thing that we've ever done. And I do think that intent matters. The article. According to Guyora Binder of the University at Buffalo School of Law, the modern felony murder doctrine is best understood as a distinctly American innovation. Although it was first applied early in the 19th century, use of the charge surged in the 1970s when the era of mass incarceration began. 50 years later, Binder contends, no country relies on the doctrine more. Is that not the American way? Here's the thing about the US often is that there will be practices that may have existed in the world. For example, enslavement. But America takes it and makes it uniquely its own. And more often than not, it becomes exceedingly cruel in the implementation. Why is that? A question for consideration. Continuing the article. In Tulsa, two men attempted to steal some copper wire from a radio tower and accidentally electrocuted themselves. One of them died, and the other was charged with first-degree murder while recovering from his burns in the hospital. The girlfriend of the deceased was also charged with murder for having driven them to the tower. In Topeka, a 22-year-old made the mistake of hiding his gun atop his girlfriend's refrigerator. He was charged with first-degree murder several days later when a child inadvertently fired it at a 13-year-old girl. In Minneapolis, a 16-year-old girl who sat in the car while two older men killed someone in a robbery was charged with felony murder. Deemed too young to enter the adult prison population after her conviction, she was placed in solitary confinement for months, purportedly for her own safety. In Somerville, Tennessee, last May, three teenage girls overdosed on fentanyl in their high school's parking lot before a graduation ceremony. Two of them died, and the surviving girl was charged with murder. I just want to take this time in that passage to highlight how vast. There are no real parameters on the felony murder charge and what falls under felony murder. That's dangerous. That feels like a degree of absolute power that can be wielded at will. And again, this varies by state, and what we'll talk about a little later in the series is about how some states are amending their laws to have more parameters in place, but that currently isn't universal or standard. Continuing the article. For prosecutors, the felony murder rule offers an efficient path to conviction. Winning a case is much easier if you don't need to prove a person's mens rea or guilty mind, or even, in some cases, to establish that the accused was at the scene of the crime. 48 states now have some version of the statute. Charlie Smith, the president of the National District Attorneys Association, told me that the tool is particularly useful in cases with vulnerable victims, such as an elderly woman in a wheelchair who gets assaulted in a purse snatching incident and dies. The community would feel it's not reasonable if the old lady's death was just a simple misdemeanor assault, he said. Prosecutors often employ felony murder when a death results from an armed robbery, a category of crime that Smith contends, in the spirit of Hawkins, carries death as a foreseeable outcome. Another benefit to prosecutors is that the steep penalties often attached to felony murder, including life sentences, compel defendants to plead guilty to a lesser charge. We shouldn't underestimate how many plea bargains occur in the shadow of felony murder charges across the country. Iko Yamka, a law professor at the University of Michigan, told me. It is one of those quiet drivers of mass incarceration we never acknowledge. That is really reminding me of the documentary Time, the Khalif Browder story. If you haven't seen it, I highly recommend you checking it out. But it really is a real life examples that highlights what we were just reading here about how these extreme sentences in tandem with individuals who cannot afford great lawyers and are used to get people to take these long sentences. And it's really honestly quite sad. But Time, the Khalif Browder story, is worth the watch. It highlights this in a real world example and about how the law can be used against citizens and forces their hand to make decisions that are not best and not to their advantage for fear of even more detrimental decisions. And in the case of Khalif Browder, he was innocent. But let's continue to go into the article and talk about how this can be used excessively. Continuing the article. Remarkably, no one knows how many people in the United States have been imprisoned for the crime. So in 2022, working with students and colleagues at the Yale Investigative Reporting Lab, I decided to try to get a sense of the scale. We started by filing public record requests to state corrections departments and other agencies across the country. To our surprise, most told us that they weren't keeping track. The records did not exist, an official at the Virginia Department of Corrections wrote in a typical response. In most states, a felony murder conviction gets lumped in with other types of murder, clouding the data. It was as if the extent of felony murder in America were hidden by design. This is where I want us to stop for today's episode. What benefit does felony murder have for us as a nation? What are the negative impacts of it? Why is it so hidden and not discussed? And most people aren't aware of it until they're faced with it. What are the long term goals they're in? And if this is something that we need to continue with as a nation. The article is not done, and neither am I. We will come back and continue to unpack this in next week's episode. But those are the questions that I want us to walk away with. As always, and until next time, I'm your illustrious hostess, Ms. Malcolm Hughes. And please remember that as long as you can rest well each night with the decisions you made during the day and face yourself in the mirror each morning with the decisions you made during the night, none of the rest really matters. It's all chatter in the end. I'll see you all in the next episode.